Your Honor. Fellow counsel, ladies and gentlemen of the jury. The evidence so far has shown that on November 17, 2016, Laura Barca was found in her apartment, deceased. She was alone. She had died from gunshot injury. And the child that she had woken up with in the morning was not in the apartment. Prosecution's charged Ms. Sesmas, and that charge is set out in jury instruction number 7. You can take a look at it if you'd like. You can take a look at any of the instructions you'd like to as I talk about them as I go through this. To establish the charge of premeditated intentional first-degree murder, they have to prove that Ms. Sesmas intentionally killed Laura Barca and that the killing was done with premeditation. And I'm going to talk about premeditation mostly for the next 30 minutes or so. That the act occurred in November 17, 2016 here in Sedgwick County. That element's not really in question. So is that what this is? Or is this something else? Questions of how and why are things that I talked to you about when we just started this case. These are important considerations for you. How and why turns on 3 major questions in the evidence. Did the death happen as an intentional premeditated act? Or was it a lesser or alternative form of homicide? Or was it something else, an unfortunate and unintentional accident? And the evidence in this case has shown you a great deal of information over the course of dozens of witnesses. There are alternative homicide jury instructions for you to consider. If you turn the page once to instruction 8, you get a sense of those many instructions that you'll be looking at. And it leads you to instructions 9, 10, and 10A. 9 is intentional second-degree murder. 10 is unintentional but reckless second-degree murder. And 10A is reckless involuntary manslaughter. And the definitions, as you look across those, and you'll have time to do that because you have these individually, the definitions are important because some of these definitions that I'm going to talk about appear in more than one alternative homicide count. Premeditation appears only in instruction 7. Intentional conduct appears in the charged offense, but also in instruction 9. Extreme recklessness appears in number 10, which is the unintentional but reckless second-degree murder. And reckless, simple recklessness appears in 10A, which is the reckless involuntary manslaughter. I'd like to talk to you for a few moments about the witnesses, witness by witness, not every witness, but some of the witnesses, thought about by subject matters, talk about whether or not we see premeditation here. So many things in this case are inconsistent with premeditated planned homicide. Catherine Rada of the WPD, she was working as a crime scene investigator at the time. She told us about going to the apartment. There was no evidence of disturbance. What she typically sees in a homicide scene is a disheveled scene. None of that in this case. What was found and not removed was a single cartridge case with a firing pin impression. Also observed were the blood spatter that you just saw pictures of with Mr. Bennett's opening or closing argument. No defensive injury on Laura Barca's arms or hands. Now, a person wanting to plan or premeditate an offense like a homicide, they might want to take some steps to remove incriminating evidence, and that was not done in the case that you have here. A person wanting to plan or premeditate an offense like a homicide might want to take steps to make a premeditated intentional killing look like something different, like a robbery or a suicide, and that also was not done here. Let's talk about Dr. Scott Kipper, medical doctor, Regional Forensic Science Center doctor, and he told us that he can share an opinion about cause and manner of death, and he did that. The cause of death was the gunshot wound, and the manner of death was homicide. And the death could have been instantaneous, is what Dr. Kipper told us. But he also shared that whether a homicide is done intentionally, or with premeditation, or recklessly, those are legal concepts. Those are your legal concepts. You decide, not Dr. Kipper from the stand. Dr. Kipper shared that he, as a medical expert and a scientist, wouldn't guess as to those legal concepts. He can say homicide, yes, but what legal type of homicide? He leaves that for you. Remember the prosecution's drinking cup example? Mr. Bennett, I believe, picked it up off our table and used it. Question about the soot and the curvature of the head of Laura Abarca. Dr. Kipper said there's no way to know why the soot shadow happened the way it did. It could be the curvature of the head. It could be something else. He didn't know, and he wasn't going to guess for you. Dr. Kipper, in response to my questions on cross-examination about an endless potential litany of explanations as to what happened, he wasn't going to guess about that either. We're left with a homicide where we know a gun was at the head of Laura Abarca and the gun discharged, but we don't know more. What about the scene witnesses? Guadalupe Noguera, the mother of Laura Abarca. She talked about Yesenia Sesmas and Laura Abarca knowing each other for years. She shared that Ms. Sesmas came to the apartment November 16th, that she saw her there. She talked about Ms. Sesmas' black truck being seen there, that she knew that Yesenia was going to come back the next day. Ms. Noguera never discussed Yesenia having a gun November 16th. She never talked about Ms. Sesmas doing anything violent or dangerous or aggressive. She never talked about Yesenia doing anything to harm Laura Abarca on November 16th, or attempting to get Ms. Noguera out of the house, or attempting to deceive anyone about Ms. Sesmas' identity or her vehicle. Now, a person wanting to premeditate or plan a homicide would want to take steps to distance themselves from the acts that they were planning the following day at the same location, if there was any plan, and that's a big if. But Ms. Sesmas did know that, leaving us to infer that as late as November 16th, there was no plan. Think about Ms. Webb, who was the neighbor of Ms. Abarca. Defense made no effort at all to impeach or question her identification, because the identification is not the issue in this case. The question is whether this is homicide, and if so, whether it's premeditated and intentional or something else. And lastly, about the scene witnesses, let's talk about Robert Thatcher of the Wichita Police Department. He talked to Lacey Webb. He also found the doorbell security camera that showed the truck of Ms. Sesmas. A person wanting to plan, premeditate a homicide might take steps to not drive to a planned murder in their own easily identifiable vehicle, particularly one that stands out as the same vehicle driven the previous day. We heard two witnesses that talked about DNA primarily. Detective Matthew Balthazar, he talked about the Q-tip swabs taken from different people, and also Sarah Gearing, witness number 15 from the Regional Forensic Science Center. She talked about the number of known standards that she obtained from Ms. Abarca's family members and Ms. Abarca and Ms. Abarca's daughter. A person wanting to plan or premeditate an offense like a homicide would have to be cognizant of the realities of DNA in the modern world. We heard many witnesses talk about phones. Sergeant Miller, Detective Guzman, Joseph Sierra of T-Mobile, and Detective Asmussen, as well as Detective Dana from Kansas City Police Department. I'm not going to go through them individually, but I think there are some common things about all of them that you should know about. They talked about the phones that they found. They talked about the WhatsApp messages on those phones. And they talked about subscriber information that they could find and call detail records, kind of like your phone bill. And they talked about things like pinging, giving law enforcement the ability to find the geolocation of a phone. None of this was tremendously cutting edge or new or things that are secret from the general public. A person wanting to plan or premeditate an offense like a homicide would want to take steps to obscure that type of information or to take steps to not create an accumulation of that type of information. That wasn't done here. With Detective Asmussen, we got a great amount of detail. Evidence regarding the phones, it is circumstantial. It is capable of interpretation by you. It may even point to a plan to do something, but it may not necessarily point to a plan to commit a premeditated murder. Detective Murray talked about the firearm and other things that he located down in Dallas, Texas. And Justin Rankin talked in great detail about the firearms and the firearms evidence and the bullet evidence and the shell casing evidence here in this case. As to Detective Murray's discussion of evidence, None of the things down in that Dallas house had been destroyed. They hadn't been obscured. They hadn't been hidden, thrown away. They were found right there in the house. And a person wanting to commit a planned or premeditated offense like a homicide would be able to take affirmative steps if that was part of their plan to make sure the items weren't at their home. The baby items in the house down in Dallas were because Miss Sesmas herself had been expecting a baby, not part of a plan. Justin Rankin talked a little bit with us about firearms. And firearms create markings on bullets as they're fired, and they create head stamp markings on shell casings with firing pin impressions as the bullets are fired. And none of that was tremendously cutting edge or secret or unknown to the general public. A person wanting to plan or premeditate an offense like a homicide might not want to leave behind incriminating evidence that could be found at a scene like a cartridge case, as was done in this case. And a person wanting to plan or premeditate a homicide would not take a firearm home where it could be found and used to incriminate them. But a careless approach to incriminating evidence by a suspect should be considered by you as reflecting a careless or reckless approach to an offense as well. Think about prosecution witness Justin Rankin also discussing the firearm and whether or not there was some sort of indicator on the firearm as to whether or not it had a live round chambered. Mr. Rankin and I talked about during cross-examination, what if he went in the hallway and loaded that firearm 2 different times and brought it in? And if he loaded it 2 different ways. One where he goes out in the hallway and he loads it and he slides the slide on top, advancing around into the chamber or the barrel. And one option where he doesn't do that. Could I, as he handed me the firearm, could I tell the difference? I'd have to manipulate it. I couldn't just look at it and tell. That's not possible. We don't know how Ms. Sesmas received the firearm in the case here. It could have been given to her by someone with a round already chambered. That could have happened without her knowing. We don't know. We can guess between those options. You can guess, but that guess leaves some reasonable doubt for you. We also don't know about Ms. Sesmas's knowledge or familiarity or training with firearms. That's also a reason that you might have to guess at, which you shouldn't do. So many things in this case are inconsistent with premeditation and a planned homicide. And we've talked about that a little bit by witness, and we'll talk more about that in a few moments. But beyond that, a person premeditating or planning could and would have realized many of these things. Gives us an inference that this was not a planned, premeditated murder. This was something far more random and chaotic. It was an unplanned and spontaneous act. In jury selection, we talked about firearms and your knowledge of firearms. Many people in America have guns and carry guns. That's not premeditation of a crime. Merely having a gun at the same time and location of a crime is not necessarily evidence of premeditation. Events can happen very quickly in an incident, and a crime can quickly involve a handgun that is present at a location, even though that was never the original intention of anyone present. Factors like a highly charged emotional situation increase the risks that a handgun present at a location becomes involved in it. I'd like to emphasize some things that we heard from Detective Ortiz Vivas of the Dallas Police Department and his discussion of the interrogation of Ms. Sesmas, along with Detective Tennyson, that we now know as Detective Palmer. Ms. Sesmas arrived for the interrogation at the Dallas Police Department and was concerned about the welfare of her 2 children. She and Laura Abarca met 7 years ago when they were working together, and Ms. Sesmas discussed meeting Ms. Abarca and seeing her and the baby and Ms. Abarca's mother at the apartment on Brunswick. And she talked about telling Laura Abarca on November 16th that she would return the following day. And Ms. Sesmas told Detective Ortiz Vivas, about Laura Abarca giving this baby to her. She said it in a variety of different ways. 6, maybe 7 times she was asked about it, and she talked about it over and over. And she talked about it repeatedly in the context of Ms. Sesmas being pregnant at the same time as Ms. Abarca, and then Ms. Sesmas losing her own baby. Detective Ortiz Vivas also talked about the Plainview man in some great detail with Ms. Sesmas, and that was described many different ways with many different details with elaboration. Detective Vivas and Detective Palmer asked about it. They asked about money. They asked about physical descriptions. They asked about what the plan was. What was the plan? And the plan was to tie up Laura Barca. It wasn't to kill her. It wasn't to shoot her. Just to tie her up, to take the baby. That's the plan involving the Plainview man. Detective Ortiz Vivas and Detective Palmer talked about Ms. Sesmas going back to Dallas with the child and why Ms. Sesmas had to go visit her aunt in Dallas first. Detective Vivas told us that Ms. Sesmas shared that she was afraid that Lisandro, her boyfriend, would do something to her, that he would do something because Lisandro was mad. She was physically afraid that he was going to injure her. And Detective Vivas and Detective Palmer talked about the firearm. It wasn't discussed in the context of being obtained to commit a killing. It was discussed in the context of being obtained to threaten. That's all part of the discussion regarding this belief about a plan and belief about the Plainview man. We got two different descriptions out of the interrogation about loading the gun. One was the person who gave her the gun had her receive the gun and she put the bullets in it, but then we have a totally contradictory description earlier in that interrogation. No, I don't know. I didn't load it or anything. I didn't load it. The guy loaded it. He did everything. I didn't know how to shoot it or anything. Things that she didn't know. So we have two contradictory narratives there. But what about whether or not we learn about a plan to kill Laura Barca in this interrogation? Ms. Sesmas says repeatedly, no, she didn't mean to kill Laura Barca. She moved. Ms. Sesmas freaked out. The gun went off. Ms. Barca was shot in the forehead. There's no plan. They asked it a variety of different ways. They even asked her, did you want to show Laura Barca that the gun wasn't fake? Yes, I pulled it back. I didn't know. I'm paraphrasing. They asked about whether the gun had bullets. Ms. Sesmas acknowledged it had bullets, but that she didn't know it was going to fire. And that she was surprised when it did fire. And as she's about to leave after Ms. Barca's been shot, she remembers the baby. And when asked, would she do this again by Detective Tennyson or Detective Palmer? No, she says, twice. She would not. So what was the thought process described by Ms. Sesmas regarding the death of Laura Barca and the taking of this child? That she didn't intend to kill Laura. Detective Palmer talked to us in some detail. Law enforcement never shared with us in this case that they ever located a pre-written out plan by Ms. Sesmas to murder Laura Barca and kidnap her child. What about the Plainview man? Was that reality? Did you get a sense as you weighed the credibility of these witnesses? Detective Tennyson told us no, it wasn't reality. We were left with the impression that perhaps it was real because Detective Ortiz Vivas didn't know. He wasn't really an instrumental part of the investigation here in Kansas. He had his part. He was kind of pigeonholed into that interrogation, so he couldn't help us. Not that he didn't want to, he just couldn't, and he was fair about that. So we shared some time with Detective Tennyson, Detective Palmer, and she told us, no, she had done the interrogation, but she also was involved broader in the investigation itself. And there's no corroboration that the Plainview man was any more than a fantasy in the interrogation room. Even though the prosecution asked, well, tell us about the description of the Plainview man. If the Plainview man and all the planning around the Plainview man, that explanation are not true, Ms. Sesmas did not actually do that planning and premeditation as to that aspect. It's a fabrication. It's an imaginary explanation of something that didn't happen. It's not proof of premeditation. Prosecution, leaving the impression that it did happen, should give you some reason to think about this case. Remember, even as you think about the Plainview man, that fictional plan was not a plan to murder, even as it's recounted during the interrogation. It was a plan to commit a fake robbery and a kidnapping, not a murder. And some of the other information which Ms. Sesmas shared with the interrogators in Dallas was also inaccurate. The part about Laura giving her child to Yesenia, that was not true. To the best you can tell, these are imaginary things also shared by Ms. Sesmas in the interrogation. And we know that because they're shared, and then as Detective Palmer tells us, they're replaced later in the interrogation by a different narrative. Now, if the part about Laura giving Yesenia the child were true, Ms. Sesmas would not need to plan and premeditate a killing and kidnapping. But if the part about Ms. Abarca giving Yesenia the child is objectively untrue, which we believe it is, but Ms. Sesmas sincerely believed it, she would still not need to plan because she'd be expecting to get the child. And if the part about Ms. Sesmas getting the child from Ms. Abarca is untrue and believed untrue by Ms. Sesmas, it's still not necessarily premeditation or proof of premeditation or homicide. The problem is that you're left to guess. Does Ms. Sesmas believe it or not? And in that space where you have to guess, there's some reasonable doubt as to the premeditation and some of the alternative forms of murder. Law enforcement at the apartment locates no evidence that Ms. Sesmas lay in wait to ambush Ms. Abarca.
You have used 20 minutes.
Thank you, Your Honor. Law enforcement at the apartment of Laura Abarca locates no evidence that Ms. Sesmas multiple times attempted to kill Ms. Abarca. Law enforcement at the apartment of Laura Abarca locates a shell casing into evidence, which means the person who fired the gun made no successful effort to remove it from the scene or keep law enforcement from locating it. And law enforcement at the scene has no proof of Ms. Sesmas surveilling the location or neighbors. Ms. Sesmas, in fact, is actually apprehended fairly quickly. And she's apprehended as a function of a number of the things that she didn't do that show that she didn't really premeditate this. They apprehended her within a few days of the incident. She didn't disguise herself when she was at the apartment on Brunswick, November 16th or November 17th. She went to and from Ms. Abarca's apartment. No mask, no gloves. She didn't obscure her transportation method in the truck that she shares with her boyfriend. It was captured on security video. She doesn't really avoid an eyewitness, and she doesn't do anything to compromise that witness's identification or dissuade it or make her unavailable. She doesn't do anything to obscure her cell phone signal as she leaves the apartment or even goes there. She doesn't obscure her boyfriend's online identity or her own online identity. These are things that a person could do if they were planning to premeditate a murder. Things that Ms. Sesmas didn't do. These are things that a person could do if they wanted to avoid identification. But they're things that Ms. Sesmas didn't do. They would all reflect premeditation, but they weren't done. In fact, Ms. Sesmas has some of this incriminating evidence at her home in Dallas, Texas. Well, let's talk about premeditation. We have it in the jury instruction, number 7. It's down at the foot of that elements instruction down here. You see it defined there. I don't have to read it to you. It's below intentionally. It's the last paragraph on the page where 7 is. Thinking a matter over beforehand. All the information in this case points to a chaotic incident. In an apartment between social acquaintances, between two women who've known each other for years. What about intentional? Well, intentional is here on 7, in terms of the murder in the first degree with premeditation, but it's also 2 pages later on a different version of homicide, a different intentional act. This is the first lesson, murder in the second degree. No premeditation here, but again we have intentional. Perhaps at some point Ms. Sesmas did have a desire to leave back to Texas with that child. The timing of that intention is a question for you to consider. Did the timing of that desire happen after the death of Laura Barca or at some other time? The evidence doesn't reflect a desire or conscious objective to kill Laura Barca here. We can use Ms. Sesmas' own words for that. I talked to you in the opening statements about you having to think about whether or not something was knowing. We're not going to have to do that. You don't have to do that. But you can consider reckless. And reckless occurs in two different jury instructions. In one form, it's a gross form or an extreme form of recklessness. And in another instruction, it's a more simple form of recklessness. So let's take a look at that. In 10, you have a more extreme version of recklessness. It requires a gross deviation. And it's defined there for you in the two bottom paragraphs. But in the other version of homicide, 10A, the involuntary manslaughter, it's merely simple recklessness. Recklessness. Is there a scenario that you can envision done by Ms. Sesmas that's reckless, where her reckless conduct results in the death of Laura Barca? There may be a scenario like that which you can picture. And each of you individually, as you go in deliberations, can have that scenario, and you can talk about that, and you can consider those scenarios collectively as a group. What might match the evidence? What looks reckless to you? What maybe looks grossly or extremely reckless? And what may not look that reckless? Was it an argument? Was there a threat? Was there a belief perhaps that dry firing an empty firearm would make a conversation more serious? Was there a slip, a trip, or a fall? Was there a struggle or not? Was it an accidental discharge in the context of a discussion about guns? We could go on and on. You could debate each one of those. You may be able to envision what reckless act occurred based on this evidence. But you'd have to imagine and fill in some blanks to get to premeditation. And there's reasonable doubt between those two, premeditated homicide and reckless homicide, which can result in you coming up with an alternative homicide verdict. Jury instruction number 3 sets out some very important constitutional rights for Ms. Sesmas. You may remember during voir dire, the judge made me pause because I was not stating it correctly. It's important that we get this one right. I was using the word slightly different than what's written here. And so you have it. It talks about the burden to prove the defendant guilty, and that she's not required to prove that she's not guilty. You have to presume that she is not guilty unless you are convinced from the evidence. It's there for you. And our request is that you render a verdict of not guilty based on any reasonable doubt that you have. But absent that, we'd like you to think about these homicide alternative verdict options for you. If not first-degree premeditated murder, we ask that you give serious consideration to the alternatives. One of them is intentional second-degree murder. That's instruction 9. One of them is unintentional but reckless second-degree murder. That's instruction 10. And one of them is reckless involuntary manslaughter. That's 10A. We'd ask that you carefully think about this. Thank you.